Welcome! Today we are diving headfirst into some serious courtroom drama. We're going to unpack what happens when a lawyer's own star witness gets on the stand and completely goes rogue. It is a super high-stakes situation, and you better believe the law has a very specific playbook for it.
Okay, just imagine this for a second. Put yourself right there in the lawyer's shoes. You've prepped for weeks, maybe months. Your whole case could be riding on this one person. They take the stand, they swear the oath, and then the story they tell is not the story you talked about. In fact, it's the exact opposite, and it's helping the other side. Do you just have to stand there and watch your case go up in flames? Or can you actually do something about it?
You know, this scenario, a witness flipping on you, is pretty much a lawyer's worst nightmare. And it can happen for all sorts of reasons. Maybe they just forgot, maybe they got intimidated, or maybe, just maybe, it's an outright betrayal. But, luckily, the legal system has been dealing with this exact problem for centuries, so there's a real framework in place.
Now, before we get to the solution, we have to understand the root of the problem. And it all stems from this old common law idea called the vouching rule. It sounds a little weird, but it's absolutely key to the whole situation.
So the rule basically says this: when you're the one who calls a witness to testify, you are, in the eyes of the law, vouching for them. It's like you're personally telling the court, hey, this person is credible. They're a trustworthy source. And because of that, the general rule is you can't just turn around and attack that person's credibility. You can't impeach them. So, what does impeach even mean in this context?
Impeaching a witness just means you're trying to show the court that they shouldn't be believed. And lawyers have a whole toolkit for this. It means asking those leading questions, the kind where the answer is kind of baked into the question itself. It also means you can bring up past shady behavior, or, and this is a big one, prove they said something completely different before the trial. Normally, you can do all of this to the other side's witness, but to your own, nope. Off limits.
And that brings us to our first category of problem witness. This is the most common one. They aren't necessarily out to get you, but man, they are not helping your case. This is what the law calls an unfavorable witness.
So an unfavorable witness is someone who just doesn't deliver the goods. You called them to prove that the light was red, but they get up there and say they're not sure. Or worse, they say it was green. The key thing here is that their testimony is a letdown, but there's no proof that they are deliberately trying to sink your case. They could just be honestly mistaken or have a bad memory.
And here it is, the main event. This is the core difference we're talking about today. An unfavorable witness, well, they disappoint your case. It's a bummer. But a hostile witness, they are actively trying to sabotage your case. The law sees these as two completely different animals, and it treats them very, very differently.
Okay, so what can you do with this merely unfavorable witness? Well, you still can't attack them personally, no bringing up their character. But, and this is a huge but, you're not stuck with their story. You absolutely have the right to call other witnesses to tell a different story. Just think about it. If witness number 1 is a dud, you should still be able to call witness 2 and witness 3 to set the record straight. You basically present all the evidence and ask the court, hey, please believe these other guys instead.
All right, let's turn up the heat. We're moving past simple disappointment now and into the territory of active, willful sabotage. This is where we meet the truly hostile witness.
A hostile witness isn't just unhelpful. The law defines them as someone who is not desirous of telling the truth for the side that called them. See the shift? It's not about the content of what they're saying anymore. It's about their state of mind. They're seen as deliberately hiding things or being totally unwilling to give a straight answer to a simple question.
This isn't some new problem either. Listen to this incredible quote from a judge way back in the 1800s. He talks about treacherous witnesses who promise to help your case, and then, because of a bribe or something else, they get on the stand and torpedo you. This is the exact kind of high-stakes betrayal the law had to create a special tool for. And here is that special tool. Once a judge officially declares your witness hostile, the entire game changes. It's like a switch is flipped. That lawyer who called them, they now get to do everything they were forbidden from doing before. They essentially get to cross-examine their own witness. They can unleash those sharp, leading questions. They can challenge their memory, their eyesight, and most critically, they can confront them with any prior statements that totally contradict what they're now saying in court.
But hold on. This is a massive power play in the courtroom. So who makes this call? A lawyer can't just stand up and yell, "Objection! My witness is hostile," and start tearing into them. No, you need permission, and you need it from the one person in charge of the whole room, the judge.
So there's a formal little dance to this. First, the witness has to actually show that they're being hostile, that they're not willing to be truthful. Then, the lawyer has to formally ask the judge for permission. And finally, the judge, who's been watching this whole thing unfold, uses their own judgment to make the final call. It's a big decision, and it's not made lightly.
So what's the judge looking for exactly? Well, it's a whole mix of things. They're watching the witness's body language, their demeanor. Are they being evasive? Argumentative? Are they refusing to make eye contact? The judge will also look at hard evidence, like a previous written statement that tells a completely different story. But the ultimate test is this. Does it look like this person is deliberately holding back and is just plain unwilling to tell the whole truth?
So we have these two distinct categories, unfavorable and hostile, with two very different sets of rules. So what's the big picture here? What's the point of this whole complicated legal dance?
At the end of the day, this whole framework isn't about giving lawyers some kind of secret weapon. It's a carefully balanced mechanism. It's designed to protect the integrity of the trial itself. These rules exist to stop a case from being totally wrecked by a treacherous witness and to give the lawyer a fair shot at getting to the actual truth. You can think of it as a crucial safety valve for the entire justice system.
And that really brings us to the final, fascinating question. It all comes down to a human judgment call. When you're looking at someone in that witness box, how can a judge ever be 100% sure? Is that person being deliberately deceptive, truly hostile, or are they just nervous, confused, or honestly just misremembering things? It's a profound challenge that gets right to the very human heart of how our legal system works.